I request the Vice Chairman of the Bar Council of Andhra Pradesh, Sri S. Krishna Mohan Garu, to come to the dais and adore the chair. I request D. Kiran Garu, advocate from Pittapuram, to present a bouquet to Sri S. Krishna Mohan Garu. I request Senior Advocate and member of the Bar Council of Andhra Pradesh and Program Coordinator Sri Ganta Ramarao Garu to come to the dais and adore the chair. I request NSV Maharshi Garu, Advocate from AP High Court, to present a bouquet to Sri Ganta Ramarao Garu. I request the President of today's function, Sri N. Dwarkanatha Reddy Garu, the Chairman of the Bar Council of Andhra Pradesh, to preside over.
My dear advocates who came all shores of Andhra Pradesh, my colleagues in the Bar Council, and before I say a word about our guest, Justice Chakravarti Garu, I thank our Bar Council member, Sunkar Rajendra Prasad, for initiation of about the criminal law. Thank you very much, sir. And it's a pleasure to see one of our Bar Council member also has become a speaker. Thank you very much. Now, as far as our guest is concerned, the electronic evidence. He presents on electronic evidence. With my own eyes and ears, I heard about this particular electronic evidence in previous seminar. That's why particularly we requested him that please pay apt attention. It's a wonderful thing in your future guidance. Take into consideration of the entire presentation of this particular subject, which is a future thing in our day-to-day life as advocates. Now I request Chakravarti Garu to take into the podium and speak and present on this electronic evidence. Hello. Yes.
Good morning, all. Learned senior advocates, ladies and gentlemen. First of all, at the outset, I thank the Bar Council of Andhra Pradesh for giving me this opportunity to share my thoughts and information which I come to know as an advocate, as a judge of the trial court, and judge of the High Court of Andhra Pradesh for the last 40 years. Almost. I joined in law in 1984 as a student of law. Now 2024, 40 years journey in this field. I have seen a lot of changes in the profession over the years. We all know that success of the legal fraternity in the profession would depend upon our dedication, determination, and discipline and commitment. Those who acquire skills of the day will survive in the system. Others will extinct in the evolution. We all know dinosaurs. One time, the biggest animal on the earth became extinct for a period of time as it could not change its living style to the change of the system. Likewise, in our profession also, if you cannot change yourself to the changing times, you may not live in the profession tomorrow. I always say that many members in the legal fraternity will believe in 3C to survive in the profession. One is by convincing the court. He will survive all through in the life. Other two, confusing the court, may be successful for some time. And the third and most dangerous thing, confronting with the court. They may not survive for longer time in the profession. You can't survive in the profession confronting with the court or confusing the court. You will survive in the profession only by convincing the court. Am I right? To convince the court with your skills, you must update yourself to the latest developments in law. As well as you must update yourself with the experience with men and matters in the life. Not only with the law, you must also update yourself with your daily experience with men and matters in the life. After all, law is a common sense. Today, with the short introduction, I'll try to share the little information which I acquired in various capacities over the period of time on the latest burning and the future of the day, electronic evidence. I request all the members of the legal fraternity to update yourself with the nuances of the electronic evidence and technology. You know, the latest laws, IPC, Criminal Procedure Code, and the Evidence Act have been repealed, and the new laws are coming into force from 1st July, very shortly, which involves a lot of provisions dealing with technology. How many of you read Section 540 of the Criminal Procedure Code? I mean to say, Nagarik VNSS, Bharatiya Nagarik. What it says, Section 540, it says, I could put, the application of 530, trial and proceedings to be held in electronic mode. All trials, inquiries, and proceedings under this Sanihita, including issuance, service, and execution of summons and warrant, examination of complaint and witnesses, recording of evidence in inquiries and trials, and all appellate proceedings or any other proceeding be held in electronic mode by use of electronic communication or use of audio-video electronic means. So practically, Section 530 is taking us to the electronic yuga in criminal jurisprudence, criminal legal system. This section emphasizes the importance of the legal fraternity to update to the technology. In coming days, if you do not update yourself, you will definitely extinct one day or other. You cannot compete with your colleagues in the profession. Okay, then coming to electronic evidence, which provision speaks the word electronic evidence? I always ask this question. Which provision in a statute, whether the Evidence Act coined the word electronic evidence? What 65B says? Present Act. What is the relevant provision in the present Act? By this time, you must update yourself. Section 61, electronic or digital record. It speaks only about record, not about evidence. Am I right? 62. Special provisions as to evidence relating to electronic record. Admissibility of electronic records. 63. BSA, the Bharatiya Shiksha Adhinayam. Am I right? Come to section 79A of the Information Section 79A of the Information Technology Act. Examiner of electronic evidence. You will find the word electronic evidence under section 79A of Information Technology Act 2000. Chapter 12A, Examiner of electronic evidence. The government may, for the purposes of providing expert opinion on electronic form evidence before any court or other authority specified by notification in the official gazette, any department, body or agency of the central government or state government as an examiner of electronic evidence. The word electronic evidence you will find here. Explanation defines what is electronic evidence. For the purposes of this section, electronic form evidence means it is giving the meaning of the electronic form evidence. What is it? Any information of probative value that is either stored or transmitted in electronic form and includes computer evidence, digital audio, digital video, cell phones, digital fax machines. This is where you will find the meaning of electronic form evidence. Evidence Act is not defining electronic evidence. Am I right? We'll come to it, sir. We'll come to. Don't worry, sir. I'll be here for 1 hour. Then, did you try to find out the difference between the Indian Evidence Act and Bharatiya Sakshi Adhinayam with regard to this electronic record, electronic evidence? How many of you made efforts to find out or to compare the relevant provisions which deals with electronic evidence and its admissibility rules laid under the Indian Evidence Act and Bharatiya Sakshi Adhinayam, which is coming into force from 1st July. I'll just read the old act. This is the way you have to read. First, section 3, document. Did you find any word electronic record in the definition of document in the old act? Document means any matter expressed or described upon any substance by means of letters, figures, marks, or by more than one of the means intended to be used, which may be used for the purpose of recording the matter. That's all. The old act, the definition of document is not touching the word electronic record. Then come to the new act. Section 2, Class D. Document means any matter expressed or described or otherwise recorded upon any substance by means of letters, figures, or marks, any other means, or by more than one of these means intended to be used or which may be used for the purpose of recording that matter and includes electronic and digital records. Am I right? First time, the word definition of document, you will find inclusion of electronic and digital records. Did you notice this difference? It is a drastic change. And in the old act, where the electronic record was included, in the old act, evidence, section 3, means and includes class 2, all documents including electronic record. All documents including electronic record produced for the inspection of the court. Such documents are called documentary evidence. In the old act, evidence definition only includes electronic record as a document. Now, what is the new act? Section 2. Evidence means and includes statements given electronically. You make a note of it. The word all statements including statements given electronically. Also part of the evidence. You underline it. Which the court permits or requires to be made before it by witnesses in relation to matter of fact under inquiry, and such statements are called oral evidence. So now oral evidence includes statements given electronically. Am I right? So electronic evidence is also now oral evidence. Am I right? Sometimes oral evidence also is an electronic evidence when statements are recorded electronically. Then coming to documents. All documents including electronic or digital records. I am stressing here, electronic or digital records. Earlier, the word used only electronic. Please listen carefully. Earlier, the word document includes electronic only. Now, another word is included. What is that? Digital record. There you are. Now, you will have a doubt. Why? Why the word digital record has been included apart from electronic? అందరికీ డౌట్ రావాలండి. My question is, did you notice earlier any judgment or any argument raised before any constitutional court, Supreme Court or High Court, that electronic records and digital records are different categories? They are not one and same. Section 65B does not apply to digital records. I produced only a digital record. It is not an electronic record. Therefore, Section 65B is not applicable to me. Did you hear such argument or any judgment in that direction? To my knowledge and to my best of efforts, I could not come across any such judgment or argument advanced before the Constitutional Court. Am I right? P.V. Anwar, no such argument, no such discussion. Arjun Pandit Rao, no such argument, no such finding. Am I right? Then why? Why the Parliament included the word digital also? To create more confusion? Already 65B is, there is a lot of confusion. No, do we want to create more confusion? More complexity? More complex things? You must pose questions like this to yourself. To become a top class advocate, you must have these type of questions. Then what is the difference between electronic record and digital record? Sir? Okay. Whether wall clock is in evidence? Sir. Just come out with some answers, sir. I invite answers. Electronic record is basically, what does it mean? IT Act defines. Am I right? IT Act defines what is an electronic record, not the Evidence Act. What is that? I'll just read the definition for the benefit of myself. Section 2, subclass T, T for T. Electronic record means data, record, or data generated, image, or sound, stored, received, or sent in an electronic form, or microfilm, or computer generated microfiche. Data, record, data generated, image, sound, stored or received, or sent in electronic form is electronic record. And anything sent in electronic form is electronic record. Am I right? Do you find definition of digital record in Information Technology Act? Whether Information Technology Act was simultaneously amended. Unfortunately, it was not amended, defining what is digital record. Technically speaking, electronic record, every electronic record is of two types. Analog records and digital records. Analog records, where information is stored or received on analog formats. Digital record is where information is stored in digital format. Digital format means in computer language. Do you know what is computer language? Binary language means 0 and 1. Anything stored electronically in digital format will always be stored in binary format, means 0 and 1. Machine language, we generally call it as. It will be stored in machine language. Machine can only read it and convert it into human readable format. That is known as digital record. Whereas analog records, certain electronic records are stored in analog format. You know, old tape recorders. Old tape recorders. Do you know? Magnetic tapes. It is also an electronic record. It is not a digital record. It's only an electronic record in analog format. Likewise, gramophones. In good olden days, who are seeing those gramophones were graphite plates. Data is stored in analog format. It is an electronic record, but data is stored in analog format. And tapes, videotapes, old videotapes, VHS tapes, data, video signals are stored in VHS format and analog format. It is known as analog electronic record, digital electronic record. So, by all means, I can say that all digital records are electronic records. Make a note of it. All digital records are electronic records, but not vice versa. All electronic records are not. Digital records are now. Nowadays, photos, as you said, sir. Digital photos, PDF documents, original computer-generated documents, Word documents, sound, MP3 sound. These are all known as digital records. Examples of digital records. So, all digital records are electronic records, whereas all electronic records are not digital records. Then, I think now I made clear myself the change in the new act with reference to meaning of electronic record. Am I right? Old law only speaks about electronic record. Electronic record means a genus word. In science, we call genus and species. Genus is the main and species is the child. Just like parent and child. Electronic record is a parent, digital record is a child. Now, we came to know the difference between electronic record and digital record. Then, admissibility. Earlier, special rules of evidence, 65A, 65B. I'm not dwelling into judgments because the time is short. Famous judgment, P.V. Anwar and Arjun Panditra. I request members of the legal fraternity, all members, particularly the junior members, to read these two judgments, P.V. Anwar and Arjun Rao Pandit. You will understand the scope of Section 65A and Section 65B and admissibility. It is only a mode of proof. I always say, certificate is only just a mode of proof. It itself does not prove the contents, truth of the contents. Probative value is different. Mode of proof is different. By giving certificate, you are just making the document admissible into evidence. That's all. You are not proving the contents as true. Am I right? It is only admissibility, just a gate to receive the document as a piece of evidence. Now, what are the changes with reference to 65A and 65B in the new Act? Am I right? What is the new change you found in the Bharatiya Sakshi Adhinayam? By this time, you must be aware of it, sir. Section 61, a new section. It is a new section. Make a note of it. Section 61 of the Bharatiya Sakshi Adhinayam 2023 is a new section. Earlier, this was not there. Electronic or digital record. Nothing in this Adhinayam shall apply to deny the admissibility of an electronic or digital record in the evidence on the ground that it is an electronic or digital record. And such record shall, subject to Section 63, have same legal effect, validity, and enforceability as other document. They are making it more clear. Earlier, there were some doubts. Now they want to clear all the doubts that electronic record is as good as any other document, provided Section 63 is complied with. Am I right? Authoritatively, they are saying that electronic record is equal and as good as a physical document, provided Section 63 is complied with. Admissibility of electronic records. I am not going into the minute differences because due to paucity of time. Now, earlier there was no form, certificate form. Am I right? Earlier, law does not prescribe the format, rather form of certificate to be provided under Section 65B. Just contents were given, but it does not provide any form. Am I right? Everybody is following their own format. Somebody is giving it in the form of an affidavit. Somebody is giving it in the form of a letter. Somebody is giving it in the form of a certificate in his own style, complying the conditions as laid down under Section 65B(4). Now, the main change in the new Act is schedules were incorporated. Am I right? Have you noticed the schedules? I am not feeling encouraged, sir. Nobody is answering. Nobody is responding. There are two parts in schedule, Part A, Part B. Part A is with regard to individual party. Am I right? And Part B by an expert. Part B certificate shall be given if an expert gives an opinion. 45A of the old Act. Examiner of electronic records. Now, equivalent provision is 39, class 2. Now, 39, class 2. Section 39, class 2 is equivalent to section 45A of the old Act. Examiner of electronic records. Expert. Same provision is now converted to section 39, subclass 2. Same provision. It says that examiner of electronic records referred to in section 79A of the IT Act 2000. I'll come to that question later. Now, certificate. Have you gone through that certificate? You are the beacon lamp of your clients. You have to guide your clients as to how to give the certificate when they produce electronic record before you. Therefore, you must aware about the contents of the certificate. Am I right? The most important thing part of the certificate is one condition. Make, model, color, IME number. Okay, these are all fine. But one complicated thing is included in the certificate. All of you must know the technology of that complicated issue. From 1st July onwards, if you doesn't know, how do you suggest and how to provide that? What is that? I state that hash value, yes, of the electronic digital record is dash obtained through the following algorithm: SHA1, SHA256, MD5, other. This is, how many of you know, can advise your client on this aspect? My simple question is, how many of you are in a position to advise your client to fill up this part? Encryption, but how to do it and what is this? How many of you know this technology behind this part? What is hash? Are you able to see it? Electronic evidence is becoming more commonplace in civil and criminal cases. Hash value is used as an important tool in examining, discovering, and authenticating electronic evidence. This main function is to authenticate an electronic record. it would be pertinent to say that it is only the significant Dominion factor which play a crucial role and widely accepted means of authenticating electronic evidence, which is also legally admissible in the court of law throughout the world. This is more important. It is legally accepted throughout the world. Now my question is, which statute in India deals with hash value and its acceptance? How many of you know? What is the provision? IT Act means Information Technology Act, sir, obviously, or Income Tax Act. But it doesn't mean you must equip yourself by this day. This is the preparation you require to become an advocate who can convince the court. If you appear in my court, how do you convince me? If I ask you what is ash, other side takes an objection that, sir, this is not in accordance with certificate provided under the law. Am I right? He reads that certificate prescribed in the act. I ask you, sir, what is ash? How it is recognized by law? Evidence Act says hash, but where the law recognizes it? In general form, if you ask me what is hash, every electronic record will have a value. Just like fingerprint for a human being. No two fingerprints will never match. That is an established science. Am I right? Likewise, an electronic record, when generated, will also simultaneously generate an electronic number which will not match with another number of other record. It is known as hash, just like fingerprint. I must say, fingerprint of the document. Hash value is as good as a fingerprint of a document. This will be generated by using certain technologies. Such technologies are MD5, message digest, MD5 technology. It was recognized all over the world as a secured technology. That a code, computer code, or computer software used to generate numerical value of the electronic record. One type of software, MD5, message digest 5. Then another form, different softwares will be there. Another form recognized across the globe is SHA, secured hash. Do you ever come across the word hash pollution? Hash pollution. Hash pollution means this is the problem for hash value. Once in a million times, there may be chance of two values matching. Very rare phenomenon. That is known as hash pollution. Sometimes Very rare. Two numbers may match. Means two fingerprints of two persons may match. Hash pollution. It was noticed in MD5 hash value once somewhere across the globe. They felt that MD5 may not be a safe one sometimes. So they developed another thing, SHA, 256-bit encryption, very secured encryption, SHA 256, a secure hash software which will generate a number. So MD5 SHA, message digest, secure hash. The Indian rules, Rule 6 of the Information Technology Certifying Authorities Rules 2000, recognize the MD5 and SHA2 as the accepted standard digital hash function. I asked this question, where you will find. And Section 3 of the IT Act. You must be in a position to support your argument, sir. Section 3 of the Information Technology Act deals with asymmetric crypto system, which is known as otherwise as hash. And Rule 6 recognize the MD5 and SHA2 256 as the standard digital hash function in India. So when you give a certificate, now you must ask your client to provide hash value also, MD5 or SHA 256 value in the certificate. How to generate hash values requires a little computer and technology knowledge. It's not a mere legal knowledge. Generation of hash value is a technical aspect. If you ask me to show hash value, I will try to demonstrate it, because I was trained technically also by the Honorable Apex Court when I was working as the judge of the trial courts at National Judicial Academy as well as National Police Academy many a times, not only on legal side and technical side. I kept a document named as Test 1, TEST test, on the desktop of my computer. One Word document generated by me for testing purpose. Now I am trying to generate the hash value. Did you notice one number, sir? Top number. 21A. Last number is A21A. Have you noticed it? Last number 1A, 21A, some numerical number. When I asked the system to generate hash number, it generated the long numerical number ending with 21 small a. I'll do one thing, sir. Problem is when laptop is connected to the font become very small. No, that is why I am doing the same thing. Now, are you able to see the number, sir? A to 1A. This is known as hash number. You can see test one document on the right side. I generated hash value for that document. The importance is if I change, why I am stressing on this is you must all aware I generated this hash value. If I change even a comma or full stop subsequently, not even some text, just full stop, even by mistake, hash value will change. If any modification, alteration, tampering was made, automatically hash value will change. So to create authenticity to an electronic record, hash system was adopted in India also. And that hash system was brought into the certificate now. Now we have to authenticate the electronic record produced before the court by mentioning the hash value in the certificate from 1st July onwards. Okay, fine, sir. Because already 11:37. I'll close with just one thing. Problem, why and what is the problem with electronic records? Vulnerability of tampering is the problem with electronic records. That is why section 65B, now 63A, only to prevent tampering, to make modifications, 65B has been introduced and hash value has been introduced. Fake electronic records is the most problem for the electronic records. For example, phone is టిఎస్ రాయల్ గారు, సార్ ఈరోజు ఉదయం మీరు ఇలా రండి. I request you, just before concluding my session for the day, I just సార్ మీ నెంబర్ ఈరోజే కదా నేను యాడ్ చేశాను వాట్సాప్లో. ఇంతవరకు మీ నెంబర్ లేదు నా దగ్గర. మీరు నాతో వాట్సాప్లో మాట్లాడారా? ఇది చదవండి. ఈరోజు మార్నింగ్ మీరు నాతో మాట్లాడారు వాట్సాప్లో. ఏముంది చదవండి. ఇది వాట్సాప్ సార్. మార్నింగ్ ఈ నెంబర్ నోట్ చేసుకున్నా. మార్నింగ్ వల్లే వాట్సాప్లో అయినా కనెక్ట్ అయ్యారు నాకు, కానీ మీ ఇద్దరే మాట్లాడుకోవాలి. ఐ హ్యావ్ క్రియేటెడ్ ఏ వాట్సాప్ రికార్డ్. నేను ఇది తీసుకుంటా ప్రింట్అవుట్, 63 సర్టిఫికేట్ ఇస్తా. నవ్ యూ అండర్స్టాండ్ యువర్ సెల్ఫ్. థ్యాంక్ యూ సార్. ఇంకా టైం ఉంటే I would have discussed with forensics. Cyber forensics means it's not the question of law. Law ఒకటే కాదు. I'm always advocates that law is only one part, but advocates must know the other side of the cyber forensics means ఇప్పుడు ఇది ఫేక్ అని ఉంది కదా, ఇది ఏ విధంగా ఫేక్, సోషల్ మీడియా మెసేజ్ని ఫేక్ అని ఎలా తెలుసుకోవాలి, ఈమెయిల్స్ ఫేక్ అని ఎలా తెలుసుకోవాలి, సిడిఆర్స్ ఇన్ఫర్మేషన్ ఎలా రీడ్ చేయాలి, సీసీటీవీలు ఇన్ఫర్మేషన్ ఎలా రీడ్ చేయాలి, అవి ఫేకా జెన్యూన్ అన్నది మనం ప్రైమఫేసీగా మన ఎండ్లో మనం ఎలా తెలుసుకోగలుగుతాం. ఆఫ్ కోర్స్ ఎక్స్పర్ట్ ఒపీనియన్ ఇస్ డిఫరెంట్ థింగ్, బట్ అట్లీస్ట్ ప్రైమఫేసీగా మనం ఎలాగా అనేది దిస్ ఇస్ ఎ డిఫరెంట్ వరల్డ్. నెక్స్ట్ టైం అవకాశం వచ్చినప్పుడు ఆ వరల్డ్ గురించి మాట్లాడుకుందాం సార్. థ్యాంక్ యూ ఆల్.
Honorable Justice BBLN Chakravarti's interpretation of the electronic evidence was very much useful in our future endeavors. Thank you for your, sir. Very nice of you. When we call you, you immediately came, because last time I saw and hear you. Now I request all the Bar Council members who are present here to come over to the dais.
I request the guest of honor, Sri Baikash Ranjan Bhattacharya Garu, senior advocate from Calcutta High Court, to come to the dais and adore the chair. I request Kamasai Garu, Professor, KL University, to present a bouquet to the Lordship. I request the Chairman of the Bar Council of Andhra Pradesh, Sri N. Dwarkanatha Reddy Garu, to preside over the session.
We are now before you, Vikas Ranjan Bhattacharya ji, a senior advocate for the Calcutta High Court and President ILU National Committee and member of the Parliament, Rajya Sabha. Your presence is endeavored by all of us, sir. Now I request Mr. Nara Srinivas Rao, General Secretary of the ILU, to introduce the guests to the audience. Thank you.
It's a privilege for me to introduce our leader, national leader, Sri Vikas Ranjan Bhattacharya ji, born on 27th November 1951 in West Bengal. Basically, a leading practitioner, very proficient in English as well as the subject. Sri Vikas Ranjan Bhattacharya served as a mayor, the biggest municipal corporation in our country, Kolkata, from 2005 to 2010. He practiced on various branches of law in Calcutta High Court, not only in Calcutta High Court, but also so many high courts in India. And in many cases, he appeared on behalf of the West Bengal government before Honorable Supreme Court also. He is not only confined to his practice in Calcutta High Court, but various parts of the country he appeared. In various high courts, he appeared as a senior counsel and including Supreme Court. Sri Vikas Ranjan Bhattacharya, elected as a Rajya Sabha member from West Bengal, currently serving as member Rajya Sabha of our Indian Parliament. Sri Vikas Ranjan Bhattacharya consecutively second time he was elected as president of this prestigious national organization, All India Lawyers Union. He is also a towering personality and a leader, visionary leader who guides us in the organization. I request Sri Vikas Ranjan Bhattacharya to take the session. Thank you very much.
To address the gathering on constitutional goals and the role of advocates.
Friends, I have been ordained to speak on Constitution and the role of advocates. First thing which we have to perceive what the Constitution is. And then immediately to go, we have to consider that the Constitution of a country reflects the character and nature of the country. An Indian Constitution, as similarly of other constitutions of the world, they have a background socio-political history. The Constitution of India is the product of a prolonged struggle against the British imperialists by the Indian people. The Constitution suddenly did not come from the heaven, or it was not the blessings of any perceived God. the Constitution of India was achieved when British imperialism was facing a threat of outright defeat, and the colonial rule was about to be completely wiped out. Then this constitution, which came to us on the blood path, that blood has never dried. East India Company, I believe you will excuse me if I try to give a little bit of historical background. History is fact. That fact may not be liking to me, may not also be liked by you, but fact remains fact. East India Company is a British company, was a British company. They traveled to India to do business. Why? Because India had huge natural resources. This part of the world has huge natural resources because of its geographical condition. And another very important resource was human resources. The Indian skilled labor, which is the product of Indus civilization, they had drawn attraction of traders throughout the world, not only the British, the Portuguese, the Scandinavians and all, but not. British started business, started exploiting at some point of time the kisans of this country, or the artisans of this country, the weavers of this country, who had shown their excellence, and that excellence was reaping benefit for the capitalists. They revolted. That was described as Sepoy Mutiny. 1857, the first war of independence. That's the way the historians of the world has described it. This Sepoy Mutiny, in fact, to my reading, was the mutiny of the Kisans. The Sepoys are ordinarily drawn from the Kisan's family. When they appreciated that they are being exploited, which they could visualize objectively, it was not necessary to teach them, you see, by X minus Y, they are getting Z profits, we are being exploited. No. They felt from their own first-hand experience, the ground realities, that they are being exploited. Whatever are produced by them is being exported to foreign countries, so to say England, and to patronize these other colonial countries. But the Kisans here are not getting their due. They revolted. That revolt was a revolt of unity of Indian people, cutting across religious consideration. British historians wanted to depict it, that this was not really the revolt against the exploitation, but this was a revolt based on religious sentiment. That was the slant given by the British historians. Now many British historians are nowadays is accepting that theory. And they wanted to divide the united strength of the Indian people. They tainted the movement as a tainted of Hindu-Muslim division on the strength of their food habit. It was said that these totas, or the bullets, if I may say so, that was made out of either cowhide or the pig hide. And that paid immediate dividend to the Britishers. We had to fight another 100 years to achieve the Indian independence. I'll just refer to two important era of this war of independence, because this is not a history class. I am not a history person. I really can't have any comment about that. Jallianwala Bagh movement, as you know, It's known to everybody. Now it has become a place of interest for the tourists. The Punjab people were brutally killed. Why? Because the Punjab Kishans and the people they were fighting, because their basic right of even take a procession was being threatened under the Rowlatt's Act. They had assembled to celebrate a social function of Baisakhi Day, as it is celebrated here in another name, and it's celebrated everywhere in the country in different name. That's the beauty of our country. Then the whole world, I mean, I am talking of the Indian community, got baffled. They became speechless. But one gentleman, who was the first Nobel laureate from Asia, Rabindranath Tagore, rose to the occasion and he returned the knighthood, which was the most coveted honor, a badge of honor by the Queen. While returning this badge of honor, Tagore wrote that this is not a badge of honor for an Indian. The Queen, who doesn't have the basic respect for the human lives and human qualities of Indian people, I cannot accept this badge of honor from that Queen. I return it. And he was very strong in his words. That created a ripple throughout the world. What happened? That someone had the courage to return the badge of honor offered by the Queen. After this, the Parliament of England, they decided to discuss the issue. That really hurt their sentiment. The General Dower was summoned before the Parliament. He was asked. He said, with all contempt, that I am really happy. Instead of feeling shame, instead of feeling indignant, I am happy. And I would have killed much more had my ammunitions not been exhausted. The killing of Indian people is the only way you can govern them. Again, the whole world started thinking, is this the civilized administration run by the Queen? Then a young boy from Punjab, a 19 years young man, Bhagat Singh, he threw a bomb during the session of Parliament. He was arrested. He was asked. He said, I am a Marxist. I don't want to kill anybody with bomb. Then why did you do it? I wanted to arouse the sentiment and conscience of the people of the world as well as of the India. Indian people are sleeping. They cannot appreciate what is going on. They were happy with the British rule, giving them some morsel here and there, laying down railway lines, laying down big roads, and giving us the idea of worldly development of India. All these things were done. Therefore, I wanted to rouse them. Let Indian people rise to the occasion. And then following that up in 1930s in Chittagong in Bengal, that Chittagong is now in Bangladesh, which is the third country created in the effect of the anti-British war. There, a young school teacher organized the young people, formed a guerrilla troop, and seized the British armory in Chittagong. And they kept under their occupation for 3 days. Obviously, there was an uneven battle. Thereafter, the British forces could reoccupy that. That was in 30s. In the meantime, Mohandas Karamchand Gandhi, who had a very bad experience in South Africa as a lawyer, came down and thought of a new method of resistance against the British regime. That was Satyagraha. His theory was, now which is being extolled globally, that I don't cooperate with you. I don't cooperate with you running your administration. My commitment is to my country. That is my truth. Commitment to the truth. I non-cooperate with you. That got the whole Indian people united. At the same time, the Second World War, you must have seen, the fascist Hitler was dreaming to crown the world with fascism. His dream was shattered by a communist-run country, then Soviet Russia. With the defeat of Hitler, the colonial forces started thinking that this is the defeat of the era of colonialism. And immediately, British Parliament decided that it's high time that we should leave India. Another signal came that with the aid of Japan, Subhash Chandra Bose, he is known as Netaji, he had formed an army of Indian people called INA. They are also marching towards India. They had entered to Manipur. All these combined forces, which was admitted by the then Prime Minister of London, England, Mr. Attlee, forced them to say, we are leaving. Now, when the movements were at the peak, in the early 1900s, two fundamental religious groups raised the voice of two-nation theory. The Indian people who have been living together years, thousands years together, who have been fighting the Britishers. The British capitalists, as you know, they are very much cunning to have their capital control throughout the world. They also fanned it. And ultimately, India faced a very unfortunate division of power. One theocratic state, they said, we believe in theology, we believe in our religion, therefore we cannot stay with others, we will go. In that background, the Indian leaders were discussing that we have to take over power, how to rule the country. This is the genesis of Indian Constitution. Because we have already been ruled. Throughout the centuries, we are ruled by others. Now we have to rule. How to rule? Therefore, a constituent assembly was constituted, drawing people from different corners of life. All are very highly intellectual people. And they had decided to make a constitution. Now, what would be the constitution? How it is to be proceeded with? To be very brief, I shall read out from the objective resolution first, which was moved by Pandit Jawaharlal Nehru, a lawyer. Pandit Jawaharlal Nehru's objective resolution is a very important document, which was the foundation of discussion of constitution making. In the objective resolution, I will not read the entire thing, it's huge. I will just place before you to give you the factual assistance, what has happened and what was the resolution, and only trying to show that this is not out of my imagination. These are all documented. Everybody of you are a lawyer or must be related to the law or the social science. If you have the opportunity, please go through the constitutional debates of the Constitution Assembly. I just place you very important part of it. I will not read the entire thing, that will take hours. He says, well, I trust that it is in that solemn spirit that we too are meeting here, and that we too, whether we meet in this chamber or other chambers, or in the fields or in the marketplace, will go on meeting and continue our work till we have finished it. Then my mind goes back to a more recent revolution, which gave rise to a new type of state, the revolution that took place in Russia, and out of which has arisen in the Union the Soviet Socialist Republics, another mighty country which is playing a tremendous part in the world. Not only a mighty country, but for us in India. Why was he referring to Soviet Russia? He says, not only a mighty country, but for us in India, a neighboring country. I just skip over a few other lines, it's not that relevant. Then if you say too much, it encroaches on the functions of those who are going to draw up a constitution. That is, on the functions of this house. The resolution is not a part of the constitution we are going to draw up, and it must not be looked at as such. The house has perfect freedom to draw up the constitution, and when others come into the house, they will have perfect freedom too to fashion that constitution. The resolution therefore steers between these two extremes and lays down only certain fundamentals, which I do believe no group or party and hardly any individual in India can dispute. We say that it is our firm and solemn resolve to have an independent sovereign republic. This is the first concept thrown to the Constituent Assembly. We want to have an independent sovereign republic. I may on going giving this reference very frequently. It must inevitably be a republic. Now, some friends have raised the question, why have you not put in the word democratic here? Well, I told them that it is conceivable, of course, that a republic may not be democratic, but the whole of our party is witness to this fact that we stand for the democratic institution. He says this is a foundation. I don't have to say this. Obviously, we are aiming at democracy and nothing less than a democracy. What form of democracy? What shape it might take is another matter. The democracies may not have to change their shape somewhat before long if they have to remain completely democratic. We are not going just to copy. I hope a certain democratic procedure or an institution of a so-called democratic country, we may improve upon it. In any event, I will read it here very slowly. In any event, whatever system of government we may establish here must fit in with the temper of our people and be acceptable to them. We stand for democracy. It will be for this house to determine what shape to give to that democracy. The fullest democracy, I hope the house will notice that in this resolution, although we have not used the word democratic because we thought it is obvious that the word republic contains that word, and we did not want to use unnecessary words and redundant words, but we have done something much more than using the word. We have given the content of democracy in this resolution, and not only the content of democracy, but the content, if I may say so, of economic democracy. Therefore, the perception of the objective resolution, which was moved by Pandit Jawaharlal Nehru, was that we will run a sovereign democratic republic. The foundation is economic democracy. I'm not reading much out of that. Now, another interesting part I have to place before you. When this issue was being discussed on the basis of this resolution. Then many voices came. The voices of that it should be a Hindu state because this is a Hindu populous country. Others said, no, this should be not a religious state. There are many more Muslims who are still in India. They continue to remain in India. They didn't want to go to the Holy Stan. Christians were there, minorities were there. Many voices came. And one interesting voice that really struck me, I shall place for your consideration, was the voice of, a speech of Mr. Jaipal Singh. He was a member of the Constituent Assembly. He was representing the Adivasis from Bihar. This statement, according to my reading, had thrown the real light of Indian society, and that led ultimately to accept the Constitution and the Preamble. What did he say? I will read out very short speech, but very interesting speech. Sir, I rise to speak on behalf of millions of unknown hordes, yet very important, of unrecognized warriors of freedom, the original people of India who have variously been known as backward tribes, primitive tribes, criminal tribes, and everything else. Sir, I am proud to be a Jangli. Adivasis of this country, they were termed by different character by the British imperialists that he was referring to. Then he says, I am proud to be a Jangli. That is the name by which we are known in my part of the country. Living as we do in the jungles, we know what it means to support this resolution. On behalf of more than 30 millions of the Adivasis, with huge cheers in the house, I support it not merely because it may have been sponsored by a leader of Indian National Congress. I support it because it is a resolution which gives expression to sentiments that throb in every heart in this country. I have no quarrel with the word of this resolution at all. As a Jangli, as an Adivasi, I am not expected to understand the legal intricacies of the resolution, but my common sense tells me, the common sense of my people tells me that every one of us should march in that road of freedom and fight together. Sir, if there is any group of Indian people that has been shabbily treated, it's my people. They have been disgracefully treated, neglected for the last 6,000 years. The history of India's valley civilization, a child of which I am, shows quite clearly that it is the newcomers. This is very important, particularly in the present context of the Indian society and the views of certain political dispensations. I read it. The history of the India's value civilization, a child of which I am, shows quite clearly that it is the newcomers. Most of you here are intruders, as far as I am concerned. It is the newcomers who have driven away my people from the Indus Valley to the jungle fastness. The resolution is not going to teach Adivasis democracy. You cannot teach democracy to the tribal people. You have to learn democratic ways from them. They are the most democratic people on earth. Therefore, the Indian soil, the Adivasis, they were telling that we are the most democratic people. We are the Adivasis. You all are intruders. Adivasis, he said, we don't have any religion. That is straight, went on speaking further. I'm not pressing that. Now, well, these discussions were there. Then ultimately the constitution was drafted, adopted. And what was the basic adoption? That is reflected in the preamble of the constitution. Now, we have decided to have a democratic sovereign republic. And ultimately, the economic democracy is the foundation of the discussions going on. Therefore, the Constitution ultimately boils down, gives its essence. Preamble is the essence of the Constitution. Supreme Court repeatedly said this is soul of the Constitution. And what does the Constitution wanted to achieve? The Preamble says that we, the people of India, consider many voices are coming and going. Ultimately, Adivasi is giving a threat. We are the original land. We are the original belongings of the country. We don't have any religion. We all, you are intruders. We belong to the Indus civilization. Therefore, ultimately, the resolution comes, we the people of India. No barrier of class, caste, creed, religion, color, race, nothing. We the people of India give unto ourselves. The Constitution was given to us by the Indian people, no one else. And what is the target? Target, it is said that we want to perceive and achieve political justice, economic justice, and social justice. This is the trinity on which we live. But how to achieve this justice, economic, political, and social? It can only be done if you have liberty of thought and expression. Liberty, not freedom. Why this question liberty came, that was also discussed. The freedom is my birthright. A baby when born, he cries. That is his freedom to protest. But the question is, will he have the liberty? If the powerful, the rulers, does not permit you to cry, what would happen? That's why the Constitution makers chosen the word liberty instead of freedom. Liberty of thought and expression. Now, expression arises only if you have an idea. You have your own thought. And thought can only be achieved if you have proper information, proper education. Therefore, the basic duty was to have the education to all, to encourage them to have their thought process and to express openly their mind. And to ensure that, you have to ensure fraternity. You have to ensure liberty of faith. You have to ensure liberty of religion. You have to ensure liberty of ideas, language, expression. Today, even our food habits are going to be curtailed. Liberty, even in case of food habit, is gone. It's sought to be made. Therefore, the Constitution makers thought one thing after having direct 200 years of anti-British war. We say the liberty of thought and liberty of expression. And this should be achieved by a republican sovereign government. How would the republic? Now, it was said that every 5 years we will elect people to rule us. Because we are the governors and we are the governed. Therefore, we will fix up our rulers. But what would they rule? It can't be monarchical rule. It can't be like that the king can do no wrong. It can't be like that the God is king and king is God. It is that we would be ruled by our own representative. But what would be the target of ruling? Achievement target is also fixed. Political justice, economic justice, social justice, ensuring fraternity and dignity of person. Preamble is very short. I am sure everybody must have gone through it. If not, please go through it. I can just quote from Justice Krishna Iyer. Once he said in a particular seminar that I would only say, my fellow brothers, read the preamble once, read twice, read thrice, read 100 times. Then you will get what the Constitution thought of and what was achieved and what is to be attained. In this background, Ambedkar, who was the final drafting authority, he said, we are going into the new era of contradiction because political justice is given. One person, one vote, one value. He was, of course, a well-known person having huge knowledge of law, society, and others. He expressed a doubt, even in the House of the Constituent Assembly, that we are entering into an era of contradiction. Political justice, but would really one man, one value, one vote be made practicable? Why? I'll come to why later. I just give an example. I was thinking to myself, now suppose in a factory owner has one vote, one value, and the casual worker has one vote, one value. A rickshaw puller has one vote, one value, and I am riding rickshaw, commanding over him has one vote, one value. Would it really be practicable? He said it would be feasible and practicable only when we can achieve economic democracy. We can achieve economic justice and transform into social justice. If I am to depend on the factory owners' whims, that if you ask me a question, freedom of thought, go back. Just now when I was entering to this hall, one phone call came from Calcutta. One casual worker of a college, he had participated in the election process, not candidate. The principal called him and said that you have participated in the election process, now you have to go back. He said, why, sir? I have done nothing wrong so far my job is concerned. He said, nothing doing. It's my desire, it's my power. You were a temporary worker, you go back. Now this gentleman will have to surrender before the authority. Save my job, sir. Tell me what to do. And whatever that person says, you are forced to follow that. Therefore, the political justice would ultimately lead us to an era of contradiction unless we can achieve economic justice. That's why the Indian Constitution, in its directive principles of state policy, apart from the fundamental rights, speaks of economic justice and removal of economic disparity. Now, this preamble, I am just diverting, this preamble that we have to achieve these three important parts, and the limb, who will make me move into that, is my independent thought, my expression. I can say, yes, you are the king, but I think you are naked. The king cannot say, you can't say I'm naked. Even if I'm naked, you have to accept it. No. Therefore, this preamble ultimately leads us to the functional part of the Constitution. Constitution is not the law, but Constitution is the source of law. We are sovereign. Sovereign means people can take their own decision. We are sovereign means no external force can interfere in our own decision running the country. But we are not sovereign to the extent of being a monarch. Our powers are limited, controlled by the Constitution. Constitution are fixed of what is to be done. Constitution ensures fundamental rights, right to equality. Freedom of expression is a part of fundamental right. Freedom of movement. Police can't come and say, yes, Mr. X, you can't go beyond this particular limit. There's no Lakshman Rekha. Indian Constitution doesn't give in Lakshman Rekha for anyone. Everybody has every right to move freely. These fundamental rights, the Constitution made it enforceable. And to make it enforceable, this is the functional part of the Constitution. The Constitution created constitutional courts. We had the civil courts, we had the criminal courts, we had many other tribunals probably. But to enforce the constitutional rights, The Constitution created constitutional courts. And Article 32 is a part of the fundamental right. That means you have the fundamental right to get justice. Your justice doesn't depend on the whims of the king or whims of the Qazi. Your justice is to depend on your constitutional right. Therefore, the Constitution made provision of enforcing of the constitutional rights, these are fundamental rights, which is Article 32. The Constitution also thought of. The fundamental rights, very well, Supreme Court will ensure under Article 32, but there are many other rights which would arise from the actions of the state authorities. There, at the state level, Article 226 gives you a particular forum of constitutional rights and other rights as well. Therefore, justice delivery system becomes one of the inalienable part of the enforcement of the Constitution and constitutional rights. You make a law, yes. You have a majority, you can make a law. But the question is, does that law runs with the constitutional principle? Can you say that, I have a right, I can make a law that I will make no enforcement of rule of law or right to equality? You have no right. I can make a law that this group of persons, like it was made by the Britishers to the Adivasis, which was reflected by Jaipal Singh Ji in Constituent Assembly, that you have earmarked as dacoits, thieves, and you have thrown us to the corner. That cannot be done. Therefore, the enforcement of the constitutional rights, the constitutional machineries were created. But what should be enforced? The enforcement is the rule of law. It's a sovereign democratic republic. Republic is the representation of the people. All people has to be treated equally under the law. Today, we cannot make economic justice. I can't say that myself and my rickshaw puller would be on the same plank. But Constitution says may not be on the same plank today. But your attempt would be to ensure that the gap of difference of income is gradually minimized. It doesn't mean that take away a Mangal Sutra from this lady and give it to other lady. This sort of wrong ideas is really destroying the constitutional basic forms. Whoever says that is against the Constitution. Constitution entrusts upon you. You have been elected on taking oath of the Constitution. By touching the Constitution in your forehead is not the functional form. You have to make it functional. By that, you have to take policy decisions which will gradually minimize the gap. But what had happened? That's why the Constitution is a dynamic instrument. Everybody says the Constitution is not a static one. Like any other sub-constitutional laws, the Constitution is dynamic. With change of time, the constitutional principles interpretation changes. And that's the beauty of the Indian constitutional jurisprudence. In the last 1 year, after the pandemic, India had been proud of 36 billionaire families. That's the report given by one of the world's most reputed economic journal, Forbes. But at the same time, the Indian people are going down and down in the hunger index. They have expressed their surprise. How could it possible? The country which is producing billionaires is going down and down to the hunger index. That shows, unfortunately, our policymakers could not make a policy which reduces the gap. On the contrary, the policy which widens the gap. We will say as a government, this is not permissible under the Constitution. I have a right to say this. And if you have a right to say this, after 10, 15 years, you will be, what do I say? You will be accused of violation of UAPA. We have seen a lady, an author. She has been inflicted with UAPA after 10 years of a speech which she had delivered. Therefore, the Constitution does not empower you. Constitution empowers you to govern according to the rule of law. Law means not anything. Law means which is permissible under the constitutional principle. Constitution says nobody is above the law. But at the same time, everybody is treated equally under the law. This equality and fraternity is the basic perception of our Indian Constitution. There are many articles. You need not be bothered about those articles. What the Constitution lovers, Constitution seekers, the Constitution perceivers, and the students will have to go by the ethos of the Constitution, which is the preamble. And that gives us the basic idea of right to equality. We have to see whether the right to equality is being gradually enforced. I again say, don't think it can be done today. But we have to see whether we are proceeding to that. At one point of time, there were government policies by which national properties were created. All these basic infrastructures belong to the nation. We all were owner of that. Unfortunately, we are now seeing that these are being gradually shifted to the private individuals. Would that again not be against the principles which has been described in directive principles of state policy? That you have to consider. I'll not take much of your time. I believe I have already taxed much. Therefore, I will conclude appealing to you that let us create a situation. Let us create a society where we can disseminate knowledge, make us more universities, more colleges, more schools. The students should go. Why should not we have 100% literacy? Literacy doesn't mean only 3 Rs. Literacy means you have a right of independent thought process. And then allow them to say. Because by criticism you are strengthened, not weakened. But by blogging the criticism voices, you are really leading yourself to a cul-de-sac situation. Let us not do that. Let the Republic. I will conclude quoting from Rabindranath Tagore. I can't really translate it. He perceived Republic is like that. Amra shobai Raja. Everybody is king. Since we are ruling the country, Amra shobai Raja, amader ei Rajar Rajotte. It's our kingdom. We are all king. And that's why we can correlate with the king. We are good and king is good. We want king to be good like us. That is the perception of Republic, and that should be achieved, and we should try for that. Thank you.
Vikas Ranjan Bhattacharya ji's Vikas Ranjan Bhattacharya ji's presentation yes. Vikas Ranjan Bhattacharya's presentation of the Constitution of India with the role of advocate. Now, you go into the depth of this interpretation. What is the depth of the speaker's interpretation of this Constitution of India and the role of advocate? It's not the question of the written Constitution of India. It's until the Constitution of India the word and deed goes to the poor, to the common, to the downtrodden, then alone the aspirations of the constitutional writers will be in view of the freedom struggle against the British tyranny. Thank you very much, sir. What I understood it, I told to my advocates. Apart from that, we have to take into consideration, particularly young advocates. I request young advocates. The synopsis of, no doubt he speaks about Constitution of India, but he speaks about the heart of a common man, the heart of poor, the heart of downtrodden, the heart of citizens, and many of the people, those who has not taken the fruits of democracy. So, my dear young advocates, share some of your views with the common people. Fight for the justice of common people also, along with your professional deeds. Thank you very much. Now I request,
with the permission of the chairman, one small announcement. Now there is no tea break. There will be another session. After completion of that session, we will have a tea break and then have a valedictory session so that we can complete the entire program before the lunch.
Thank you. Now, felicitations to our guests. I request Mr. Rajendra Prasad Ji, the working president of ILU. ILU means All India Lawyers Union National Committee, and Nara Srinivas Rao, the secretary ILU AP unit, and Sampar Srinivas Rao, the vice president ILU, and Mr. Comrade Madhav Rao, general secretary of ILU, to come over to the dais.
I request the guest of honor, Sri M.V. Durga Prasad Garu, Advocate, High Court of Andhra Pradesh, to come to the dais and adore the chair. I request Mautashi Thakur Garu, Deputy HOD, KL University, to present a bouquet to the guest. I request the chairman of the Bar Council, Sri N. Dwarkanatha Reddy Garu, to preside over the session.
I request now Mr. M.V. Durga Prasad, Advocate High Court of Andhra Pradesh, to interpret and speak about immovable properties and the documentation and whatever he feels it necessary for our advocates. Paul. Thank you.
Greetings to everybody. The topic given to me, as I have seen now, is the property loss and documentation, immovable properties and documentation. And the time is 30 minutes, less than 30 minutes. I'll have to finish at 1:50. So the documentation with regard to immovable properties. This is the topic. The immovable properties are considered to be the real property, and the title to immovable property, that the title is the title to immovable property. You will have to trace on the basis with reference to the statutes that are governing that particular property and all the factors that are required to be considered for deciding the title. For the purpose of knowing the title, you will have to know the law and also the source of law. Source of law is de facto, whereas title or right recognized by law is deserved. Now, when it comes to immovable properties, the land, you will have to know for the laws, the source of title and the law applicable to it. If it is an agricultural land, you should know what is the source. The source of title, if it is you should know the land tenures and the law relating to the land tenure. What is the nature of the property, the land? Whether it is a Jamindari village, whether it is an Inam in Jamindari village, whether it is an Inam village, you should know the land tenure to source the original title. And unless you know it, you will not be able to know the correct source of title and whether the title which of the person who is trying to sell or convey the property had correct defective title or proper title. Similarly, if this is the source of title. The next one is the record relating to the title. The land records. We have land records. The land records prepared after survey and survey records, the entries incorporated in the land revenue records and updated every year. So far as the title, the law of title in this country is concerned, we had a sort of Jamindari, Raitwari system and Jamindari system. And the Raitwari is those lands which are directly held by the right, revenue payable to the state. Whereas in Jamindari, the system is the Jamindari system is nothing but that arose out of permanent settlement. What is permanent settlement? The revenue farming rights that were granted to the Jamindars permanently are they were taken as landholders, which is not true. The reason is, in this country, the tiller is the owner. Whoever occupied the land, started cultivating, is the owner. At that time, the land is it is not the land that is wanting, land is abundant, it is the tiller who is wanting. Because the state wanted the revenue. So the land tiller is always the landholder, and what the state has is only a share in the usufruct or the crop, that is Rajabhoga or Melivaram right. The rest belong to the tiller. It is this revenue, the right of revenue to the state, that is called land revenue, that is auctioned by permanent settlement, and that permanent settlement, the Jamindar who only had a right to collect the land revenue. But in the process, the lot of controversy arose in India as to who is the real owner. The Britishers who had the manor system, they understood that the landholder is the Jamindar and the tiller is the tenant. But tiller is not the tenant, he is the owner. From then, there is a lot of agitation in the manner in which these Jamindars were evicting the tillers. Therefore, Estate Lands Act 1905 was brought. And after the independence, there was reforms in land tenures. The major estates were abolished by the Jamindar Abolition Act, and the minor estates were abolished under the Inam Abolition Act. And the patta was to be granted to the tiller under section 11 and to the landlord under section 15, the Jamindar. And so far as the Inam Abolition Act is concerned, the Raitwari certificate will be issued. In respect of the land which is directly under the British rule, the Raitwari lands, the patta was granted on the basis of, patta is recognized on the basis of the original, whoever was the tiller, he was recognized as a pattadar, and he was the khatedar. That means he will have a revenue account. He will have to pay the land revenue. If he doesn't pay, then his account will be deleted and the property will be put to auction. What does it mean? If it is put to under Revenue Recovery Act, that means the title is held by the khatedar, the pattadar. This is how the agricultural lands title is traced. When it comes to urbanization, slowly the land records are maintained. Land records are maintained by the urban bodies, and the property tax register is taken as similar to the Adangals to show the possession. When it comes to documentation, that means the transfer of property. Transfer of property has to take place in accordance with law. The Transfer of Property Act does not confine only to the immovable properties. It is only from section 38 to 53A which exclusively govern the transfer of property. What are the properties that can be transferred, what can't be transferred are mentioned in section 6, and what are the principles that govern the transfer of property. Different principles. Property is not defined in the Transfer of Property Act. Property, and if you see the different provisions of the Transfer of Property Act, it applies both to the movable properties, immovable properties, tangible, intangible, and the rights in the property, even the actionable claims also. If you see the definition of exchange, you will find that it governs not only the immovable properties, both movable and immovable properties, but also money, even exchange of money. If you see that definition, and kindly see the definition of exchange. 107 118, when two persons mutually transfer the ownership of one thing for the ownership of another. It's not land, it can be anything. Neither thing or both things being money only, the transaction is called exchange. That means if it exchange, there shall not be, it can't be exchanged for money. It can be exchanged for anything other than money. And money can be exchanged with another money. So exchange can be of any property, of anything. And if you see 121, you will know. On exchange of money, each party thereby warrants the genuineness of money given to him. That means neither of them should be, it is like this, neither thing or both things. Exchange, money can be exchanged only for money. Other things, anything. You can exchange an immovable property with movable property with immovable property, or an intangible property, anything. But when it comes to money, it has to be money for money only, for an exchange. And when you see the definition of sale under section 54, you will clearly find sale, mortgage, and lease. These three provisions relate to only immovable properties. And when you see the definition of sale under 54, sale is a transfer of ownership in exchange for a price paid or promised, or part paid or part promised. So only if it is for exchange of a price, that is money, it is sale. Otherwise, it doesn't come under sale, but it comes under exchange, and it will be governed under the conveyance. It falls under Article 20 of the schedule of the Stamp Act. Sale how made? Such transfer in case of tangible immovable property of the value of 100 rupees or upwards, or in case of reversion or other intangible thing, can be made by a registered instrument. It says the procedure in what manner these can be done. The transfer of the sale of tangible movable property, that is what is visible, and intangible right in the immovable property, what is not visible, what cannot be seen. So a sale under section 54 covers not only the immovable property, but any right in the immovable property, tangible or intangible. These rights, any right in the you want to transfer any one right, ownership is a bundle of rights, and you want to convey the entire ownership, but subject to certain conditions, certain limitations, then it is sale. You have the right to enjoy the property and transfer that right of enjoyment, it is lease. You have a right to sell the property, and you want to transfer the right to sell that property or transfer the property to secure a debt, that is mortgage. You create a right in favor of somebody, right of way, or right to let the water or pass some other drainage water or rain water. All these are easementary rights. That, no doubt that easements, we have a separate enactment, but it is also a right that is being transferred. Now, when we come to the documentation part, we have to see that there are certain restrictions, and in case of immovable properties, Transfer of Property Act, you all know, governs only the transactions inter vivos between two living persons. If it is not a transfer between living persons, that is Succession Act which governs. So the principles subject to which a property can be transferred are similar, whether it is between living persons or from non-living persons. The provisions relating to the principles of perpetuity, right to rule against perpetuity, and other rules which we find in the Transfer of Property Act, the conditions, precedent condition, vesting factors, all these are similar provisions are there in the Succession Act also. Therefore, what I want to emphasize here is the same principles you will have to keep in mind while you are drafting a will. And will contains, the Succession Act contains many other provisions relating to the will, which we don't find in the Transfer of Property Act. And when the will gets defeated on account of the subsequent death of the, if the legatee dies before the testator, the will becomes cancelled. There are several other provisions which we need to keep in mind while drafting the will. And another factor we need to keep is every transfer of immovable property need not be in writing. Section 9 of the Transfer of Property Act clearly declares that unless the law requires a particular transaction should be in writing, it can be oral. So all oral transfers are permissible unless the law says otherwise. The rule is oral transfers are permissible. Exception is they should be, the law must say otherwise. What are the oral transfers permissible? The greatest example is partition. Partition happens when the co-owners are either, joint tenancy and tenancy is in common. Either joint property or the legal heirs inherit the property, they are co-owners. 2 or 3 purchasers come together and purchase the property, they are co-owners. And the way they have to, the joint property becomes a separate property is by way of partition. And in such case, what happens? The transfer happens, a particular property that is allotted to a particular sharer becomes his absolute property. The transfer takes place. Such a partition can be oral. And the release or relinquishment is another factor, is another transfer which can be oral, because there is no law which says a release or relinquishment has to be in writing. But this is, once the writing takes place, if you want to put it in writing, then there are 2 other acts which apply. What are those? The Stamp Act. It is a taxation on the document, a fiscal enactment, but it has got certain disqualifications if it is not properly stamped or it is not stamped at all. Therefore, when you when you draft a document, you will have to know whether the transaction, oral transaction, has already taken place, or you want to affect that transaction under a document. That makes a difference so far as the Stamp Act is concerned. How? An instrument is, every document does not is not, every document is not liable to stamp duty unless that document is an instrument under the Act, under the Stamp Act, and it is chargeable under Schedule 1A, so far as the state is concerned. That is the why, because there is Schedule 1, which is the part of the Central Act, but under the Constitution, though the stamp duty is in the concurrent list, so far as the rates of the stamp duty are concerned, it is in the state list and also in the central list. Central list, that is list 1 of the Schedule 7 of the Constitution, only contains it is a union which has the power to regulate the rates of stamp duty so far as the promissory note exchange of bill of exchange is concerned. All other are governed by the state list. That is the reason why the states have the power to regulate the rates of the stamp duty. They have their own independent schedule, Schedule 1A, each of the state. So therefore, except bill of exchange and promissory note, these all other documents which are mentioned in the Schedule 1A are liable to stamp duty in the manner shown in the schedule. So if a particular document requires stamp duty or not, it has to be an instrument and it should be mentioned in the schedule. When it comes to a document which is not an instrument, under which the transaction is not affected, the rights and liabilities of the parties are not created under the document, then it doesn't require stamp duty. So a memorandum of past partition was not considered to be liable for stamp duty for a long time, till legislative intervention was made by an amendment in 1996, where the instrument of partition, the definition of partition is amended by adding the words instrument of includes a memorandum of past partition. But when it comes to other documents, similar, you make there is a release, or under a hiba, there is a Muslim gift, which can be oral, which is exempt from the provisions of the Transfer of Property Act. If you, because you want either there is a oral gift, oral partition, but you want to effect mutation, they want some document. Oral means you convey orally, the authority may not accept, he may issue notice to all the shareholders, and if he comes and agrees, he may effect the mutation. Another way is by way of an affidavit that we have already shown, shared the property, joint property, shares are distributed in this manner. This particular property has gone to the share of XYZ. And there is an amendment in Telangana Record of Rights, new Record of Rights Act 2020. This is a very important for the purpose of our discussion, 2020 Act, because there is the documentation part, drafting, conveyancing is concerned. It is the knowledge, experience, and skill of the lawyer that goes into it. But a lot of legislative changes are coming. Earlier, there was a lot of freedom so far as the drafting is concerned. This freedom is initially intervened by amendments to the Stamp Act. They, in the name of leakage to the revenue or loopholes in the act, amendments came to be passed from time to time. For example, the agreement of sale, still agreement of sale is liable to stamp duty. The maximum was 100 rupees earlier. In Tamil Nadu, even today, 100 rupees only. In West Bengal, it is still 100 rupees. But in Maharashtra and following Maharashtra, United Andhra Pradesh, 1996, there was an amendment. If an agreement of sale coupled with possession, it must be treated as sale. And there was an amendment to section 6, 6A, 6B, 6C were made. And there was also an amendment to the GPA, saying that if you earlier also GPA, if conferred with if it is irrevocable, it was like conveyance. Now, on account of the urbanization, the rulers, they thought that more and more revenue can be derived by taxing those instruments which are commercial in nature in the real estate. So these developers, they have not purchased it for the purpose of cultivation or keeping it. They develop the land, and the developed products, whether it is flat or a plot or independent house, it has to be sold. It is and therefore they don't want to pay the entire duty on the they don't require a sale deed. They were taking only GPAs, or some people agreement come GPA. The government thought this agreement of sale come GPA should be taxed. Section 6B, Article 6B of the Stamp Act, it says, I don't have the book, it says, if the property is for the purpose of, if it is for the purpose of development and sale of apartment and construction, then the estimated value of such construction or development shall be the criteria for the agreement. It is the estimated value. And then whether there is a lot of controversy whether section 6, the article 6B applies to agricultural lands or open lands, because there is no construction is contemplated, and mere agreement of sale without any contemplating any construction are held to be liable for stamp duty under 6C for a fixed stamp duty by a division bench and of the United AP, Justice Bhikshapati and Justice P.S. Narayana, and still no sub-registrar accepts it. There will be this, if you go for registration, because now by an amendment, even Section 17 of the Registration Act is also amended, making agreement of sale compulsorily registrable. Of course, so far as the, except for specific performance, it cannot be taken as an evidence. It cannot affect the property. All the vices of non-registration will be attached to it. So the challenge for these documents is that you will have to know the stamp duty, and registration. When it comes to registration, the certain enactments were also came to be passed, where the document has to be in the prescribed form. Section 13 of the RERA Act prescribes, says that the agreement has to be in the prescribed form. So the rules are framed. There is a format you will have to follow. There is no question of your skill, your experience and knowledge can be applied in this, because it is to be in the prescribed form. And a latest 2020 Telangana Record of Rights Amendment Act, not amendment, new act of 2020, is a very small act. What it has done is, section 5, the documents relating to sale, gift, conveyance, etc., lease, have to be in the prescribed form. You have no option. Whether it suits your requirements, whether it really transfers the property, you can't help, because that is the law. And they have prescribed a format. If you see the format, it doesn't, because this is how the technology is giving, the technology, in the name of technology, the law which we apply for the purpose of knowing the title or transfer of title, all are given a go by. For a simple example, the technology doesn't permit you, whoever is that it's a joint property, either by way of inheritance, or on account of joint purchase, or on account of the joint family. But the pattadar name, only one of the persons will be treated. As per Dharani, you cannot, nobody can be vendor except the person whose name is found there. So, though under law there are several owners, the executive law, that is the procedural law, recognizes only one. One is the owner, only he can be the vendor. For a long time, there is no other provision even to be the consenting parties. Consenting party, at least to other shareholders to bring as a consenting parties, it is after 1.5 year agitation, the government permitted consenting party, but only as a consenting party, not as vendors. And a consenting party means you are not transferring the property. There are 10 people shareholders. One of them who is having only 1/10 share, he will transfer the property. Others will agree to it. Then there is no transfer of properties taking place. What is happening is, you want to bind the other shareholders by principle of estoppel, not by transfer, because this is the compulsion of law. This is how our land administration is so indifferent, or even arrogant, or unmindful of the consequences. And in Karnataka, it is still worse. At least they will only permit witnesses. And the lawyers started writing consenting witnesses. There is, so far as we know, witness is a witness. He is not party to the document. He is only an attestor. He is a witness to the signature, not to the contents. He doesn't know anything. I signed, you attest, anybody would attest. He cannot be attributed knowledge of the contents. And at any rate, it cannot result in the transfer of property. There, even the principle of estoppel, to apply the abstract principle of estoppel also is difficult. And you have seen here, Land Titling Act. Of course, now it is repealed. The government is yet to pass probably the ordinance. But in principle, it is agreed to be repealed. We will not go into debate whether the merits and demerits of the act. What is its impact on the documentation? The Titling Act, unlike the Telangana Act, doesn't deal with the documentation or registration part. What it says is, it can it recognizes the person who is registered as the owner. There is no provision under that act also to, though ownership is a bundle of acts, tenants and mortgages are also mentioned, but other rights, no certification is required for every right which is mentioned there. And you will have to inform whatever right you have acquired, that also requires certification. It has nothing to do with the transfer as such. You execute whatever right you have acquired by way of inheritance, by way of document, etc. You will have to go intimate and obtain a certification. If you don't do any such, don't obtain such certification, then your right cannot be enforced. That is how it is. In case of disputes, this is the most controversial part of the act. All the powers are given to the officers of the government, though the adjudicatory powers should be given to the courts. Anyway, my time is up. Thank you.
Thank you, Durga Prasad Garu. In fact, we should have utilized his time, but time is up. There will be announcement. There will be already chief guest of the valedictory function arrived in the campus. Some of the members requested whether the certificates can be given through the chief guest and other dignitaries on the dais. It all depends upon the availability of the time. Have a quick tea break. We will have small tea break for 10 minutes. We will reassemble after 10 minutes. If the time is available, we will explore that possibility. Please come quickly so that we can proceed with the next program, which is very important program, and conclude the complete program.
Brother. Brother. ఒక నిమిషం.
చేసన్నా వేయాలి కదా బాధ.
ఈ యాంగిల్ తిని.
I request all the advocates to be seated in their places. We are commencing shortly. I repeat, I request all the advocates to be seated in their places. We are commencing shortly. I request Lavanya, fourth year student from KL Law College, to perform a dance, a classical dance.
భరత వేదముగ నిరత నాట్యముగ కదిలిన పదమిరీశ శివని వేదనగా వని వేదనగా పలికెను పదము పరేశ నీలకంఠరా చాలి పొందరా కరుణతో నలుగనరా నీలకంఠరా శైల మందిరా మొరవిని బదులిడరా నగజామనోజ జగదీశ్వరా కాళేందు శేఖరా శంకరా భరత వేదముగ నిరత నాట్యముగ కదిలిన పదమిరీశ శివని వేదనగా వని వేదనగా పలికెను పదము పరేశ అంతకాంతని సతి అగ్ని తప్తమైనది నేను త్యాగమిచ్చి తాను నీలో లీనమైనది ఆదిశక్తి ఆకృతి మాతృజాత పార్వతి తానువైన ప్రాణధముని చెంతకు చేరుతున్నది భవుని భువికి తరలించేలా ధరణి దివిని తలపించేలా రసతరంగిణి వేళ ఎదని నృత్య రకులు చేయగలిగి వేళ భరత వేదముగ నిరత నాట్యముగ కదిలిన పదమిరీశ శివని వేదనగా వని వేదనగా పలికెను పదము పరేశ వ్యోమకేశనిను హిమగిరి వరసుత ప్రేమ పాశమున పిలువంగా యోగి వేషని మనసున కలకద రాగలేశమైన హేమహేషని భయద పదాహతి దైత్య శోషణము జరుపంగా భోగి భోగి భూష భువనాళిని నిలుపవ అభయ ముద్రలోన నమక చమక ముల నాదాన యమక తమక ముల యోగాన పలుకుతున్న ప్రాణాన ప్రణవనాద ప్రథమనాద శృతి వినరా
దీని తర్వాత ఈయన కూడా పిలవాలి మమ్మల్ని ఓకే ఒక 2 నిమిషాలు సెట్ చేయి. అమ్మా మీరు స్టార్ట్ అమ్మా మీరు దీని తర్వాత చక్రవర్తి
I request everyone to please be silent. I repeat, I request everyone to please be seated in their places and please turn on your mobile phones onto silent mode. I request the Honorable Sri N. Dwarkanatha Reddy Garu, Chairman of the Bar Council of Andhra Pradesh and President of today's function, to come to the dais and adore the chair. Prashant Kumar Mishra Garu. Enrolled as an advocate on September 4, 1987, he practiced law in District Court at Raigarh, High Court of Madhya Pradesh at Jabalpur, and High Court of Chhattisgarh at Bilaspur, and dealt with civil, criminal, and writ branches of law. He was designated as a senior advocate by High Court of Chhattisgarh in January 2005. He had been chairman of Chhattisgarh State Bar Council. He was appointed member of the Rule-Making Committee of High Court of Chhattisgarh. He had been Chancellor's nominee in the Executive Council of Guru Ghasidas University, Bilaspur. He was associated with Hidayatullah National Law University, Raipur, as its ex officio member in the Executive Council. He served as Additional Advocate General for the state of Chhattisgarh from June 26, 2004 to August 31, 2007, and thereafter as Advocate General for the state from September 1, 2007 till elevation. He was elevated as a judge of High Court of Chhattisgarh on 10th of December 2009. He was acting Chief Justice of High Court of Chhattisgarh from 1st June 2021 to 11th October 2021. He was appointed as Chief Justice of High Court of Andhra Pradesh and assumed on 13th October 2021. He was elevated as Judge of the Supreme Court of India on May 19, 2023. I request the Chief Guest of valedictory session, Honorable Sri Justice Prashant Kumar Mishra Garu, Judge of the Supreme Court of India, to come to the dais and adore the chair. I request Sri Y. Nagireddy Garu, Member, Bar Council, to present a bouquet to His Lordship. I now request Honorable Sri Justice B.V. L.N. Chakravarti Garu, Judge, High Court of Andhra Pradesh, to come to the dais and adore the chair. I request the Vice Chairman of the Bar Council of Andhra Pradesh, Sri S. Krishna Mohan Garu, to come to the dais and adore the chair. I request Member of the Bar Council of Andhra Pradesh and President of the AP High Court Advocates Association, Sri K. Chidambaram Garu, to come to the dais and adore the chair. I request Senior Advocate and Member of the Bar Council of Andhra Pradesh and Program Coordinator Sri Ganta Ramarao Garu to come to the dais and adore the chair. I request Dr. K. I. Pavan Kumar Garu, Principal, Law College, KLEF University, to come to the dais and adore the chair. I request V. Chandrasekhar Reddy Garu, Member of the Bar Council of Andhra Pradesh, to come to the dais and adore the chair. I request S. Brahmanandra Reddy Garu, Brahmananda Reddy Garu, the Member of Bar Council, to come to the dais and adore the chair. I request P. Narsingarao Garu, member of Bar Council, to come to the dais and adore the chair. I request Y. Nagireddy Garu, member, Bar Council of Andhra Pradesh, to come to the dais and adore the chair. I request Sunkara Rajendra Prasad Garu, member of AP Bar Council, to come to the dais and adore the chair. I request V. Brahmareddy Garu, member of Bar Council, to come to the dais and adore the chair. I request the chairman of the Bar Council of Andhra Pradesh, also today's president, to preside over the session.
Today is a very fortunate day for all the advocates who gathered here from the shores of Andhra Pradesh for the 3-day orientation program. I welcome the Supreme Court Judge Prashant Kumar Mishra and all the Bar Council members, and also the Honorable Justice Vivilan Chakravarti, High Court Advocate, Justice, Judge of the High Court, and also the Principal of Law College, and all the members, Pavan Kumar. Now I just recollect. It is last year, sir, you are here for the inaugural function of the same program. How fortunate we are. Give big ovation. Now today is valedictory function. How nice for 1 year. The chief guest, our Honorable Supreme Court Judge Prashant Kumar Mishra ji, will also want to know from all of you, for all this 1 year, how you imbibe yourself from the orientation program, which our Lordship has addressed last time in the inaugural function and today's function. Yes, I will tell. When last time, when the inaugural function was addressed by our Lord Justice Prashant Kumar Sindha ji, he was the Chief Justice of Andhra Pradesh. After the meeting, a very good news we received from the Delhi sir, that you are elevated as the Supreme Court Judge. Not for the sake of the advocates, sir, for the sake of the entire humanity, for the sake of the poor people, for the people of the downtrodden, and for also to see the rights of the constitutional things has to be protected by the Supreme Court. I hope, sir, we are very happy that under your golden hands, this, whatever I say and whatever our advocates say, you are doing very best and accepting our invitation in spite of the summer vacation. So, many of our High Court judges is unable to come to our orientation program because of summer vacation. But in spite of it, summer vacation, the Lordship has to present here with a love and affection, not only on the Bar Council, but also on the state of Andhra Pradesh. Your footprints is still in the judicial field of Andhra Pradesh, sir, everywhere, from Tirupati to Srikakulam, from Srikakulam to Kuppam, Kuppam to Tada, and other places also. How fortunate we are. And particularly Bar Council of Andhra Pradesh is very fortunate because he was the chairman of the Bar Council of Chhattisgarh. That means he is a part of our hearts, sir. Thank you very much. This is the time. It's already 1:45. I don't want to say more than that. I welcome you, sir, for this program, orientation program. And I hope, sir, as I am an elderly man, may God bless you with all happiness. Lord Venkateshwara bless you with us. Thank you. Now I request the principal of KLU Law College, Mr. Pawan Kumar, to address the gathering.
Thank you very much for this opportunity. Indeed, College of Law, it's, pleased to organize KL University, pleased to organize such a wonderful event. I have seen in the morning while serving the breakfast, sharing the ideas with some of the participants. They're enthralled to come again to this campus and participate in this kind of event whenever Andhra Pradesh Bar Council is willing to organize. And my assurance on behalf of university, in absentia of Vice Chancellor, on behalf of the President, that whenever this kind of academic activities are planned, you please choose KL University, Law College, any academic activity with reference to law, with respect to law, national seminars, international conferences, brainstorming sessions, you please suggest us. Human resources are available, infrastructural resources are available. Students, you see how dedicated they are, 24/7, they are at the beck of a call, they are available. So use the resources here, intellectual resources here, join hands with the College of Law. Rest assured, we are with you forever. Thank you all.
All the advocates who gather here, along with guests and the Bar Council members, are very eager of hearing some of the salient features of his life and also the advice to the young advocates and also the other advocates by our honorable guest, Justice Prashant Kumar Mishra, Supreme Court Judge.
My esteemed brother Justice B.V.L.N. Chakravarti, Sri Dwakanath Reddy, Chairman Bar Council of Andhra Pradesh, and a prolific speaker it seems. See, I missed that deliberately, since it's a different kind of gathering. Sri S. Krishnamohan, Vice Chairman of the State Bar Council, Sri K. Chidambaram, President AP High Court Bar Association. Since I am meeting him for the first time after his election, I congratulate him. Sri Ghanta Ramarao, Senior Advocate, the Program Coordinator and the former Chairman of the Bar Council. And he, along with Nagi Reddy, who initiated the entire event, connecting me to this valedictory function. Sri V. Chandrasekhar Reddy, Sri S. Brahmanand Reddy, Sri P. Narasimha Rao, Sri Simkara Rajendra Rao, Sri V. Brahmanand Reddy, all respected members of the Bar Council. Sri Pawan Kumar, the maverick dynamic principal of the Law College here. A very good afternoon to all of you. And at the outset, I feel delighted, not only delighted, but honored and privileged to be here again in this August house, in this auditorium, to deliver this valedictory lecture in this residential orientation program of 3 days. And it is, as it was put to you by the President, very rarely it happens that in the same program, almost same program, one would get the opportunity of inaugurating also and then being a part of the valedictory function also. I am fortunate to have that occasion with me. It started sometimes in first week of or last week of May, that Ghanta Ramarao called me, and then Nagi Reddy called me back to back, saying that can you please inaugurate this second volume, of this orientation program. I was in a fix because I was holding my vacation court sitting from 3rd of June to 16th of June, that is today. Today also I was supposed to be in the Supreme Court, not holding the court sitting, but I was required to be in the station because that is the requirement of a judge, for a judge who is holding vacation sitting. But then I could not resist the temptation of an invitation, refusing an invitation or accepting whatever you may call, the temptation of going and coming amidst you once again. Then I spoke to Honorable Chief Justice of India, can you please spare me for one day? He said that there are other judges available in case of any emergency, other judges will be available. You please go and enjoy your association with the lawyers and the Bar Council of the Andhra Pradesh. And this is how I am here once again. This residential orientation program is one of its kind in the entire country. Orientation program happens in different bar council. Some would perform and complete the ritual of an orientation program in a one-day program or a half-day program, 1 or 2 lectures of any prominent speaker, dignitary. But I have not seen the residential orientation program elsewhere in any bar council lasting for 3 days. And that is unique with the Andhra Pradesh Bar Council. I must congratulate them for this endeavor, this hard work. You see, training of lawyers has become a lip service for the bar councils. But it is not so with the Andhra Pradesh Bar Council. And that shows the passion and commitment of the Bar Council of AP
to train the young lawyers. And that is why I have found the quality of lawyer during my stint here as the Chief Justice, the quality of lawyering or advocacy was at such a good position when I compare that with the quality which we have faced in MP and Chhattisgarh at that point of time. Even in other states which I have visited when I was chairman of the Bar Council, language only doesn't mean the quality. One may speak very fluent English, but the quality of the content or the legal submissions which is contained in that oratory inside the court is one good thing which I have found in the lawyers of Andhra Pradesh, be it in the High Court when I was there, or I'm seeing it in the lawyers belonging to this area when they appear in the Supreme Court also. So that is one great thing. And I was going through this. Invite, the whole invite, and the topics which have been chosen. The topic starts from CPC with special reference to execution of decrees and orders. You see, the inaugural topic starts with execution, not with pleadings, but execution. And I was thinking, why this inauguration has started with execution? But then I could connect it with the problem Indian judiciary or the Indian judicial system or the legal system is facing, because there is an old saying, we have found that in the judgments of Privy Council, that in India, the litigation starts when the decree is put to execution. And it's a widely thought inaugural address. Our problem starts when the man is armed with a decree. So that is one. Then the second topic of law leaves the lawyer's way. This is also a very apt topic. Law itself really is molded the way lawyers try to make it and shape it. Most of the time, we give a different trajectory to the law which is already laid down. The law which is already settled for decades is unsettled, not because of judges, but because of the lawyers who raise a new point and give a different dimension by way of interpretation, because the society is growing and the complications in the day-to-day life compels an individual, whether he is a litigant or he is a lawyer, to think the same problem in a different way. And when the same problem is put in a different way by way of different interpretation, the judge facing with the contemporary difficulties in applying the law which is settled decades ago, he is compelled to think that why can't we approach this problem in a new way? Because what happens, the lawyer's mind is such ingenious mind that when a law is settled in a particular way, they will find ways and means to overcome that problem by way of a settled law, and then a new set of pleadings will start to avoid application of that settled law, and the new set of pleadings in a new set of facts after decades would throw a new kind of interpretation. And that is why The second topic is also very apt, that it is lawyers who wishes to give a different picture or projection to the law of the land. And this new laws, this Nyaya Sanhita, all CRPC, IPC in the new avatar, that is really going to throw a big opportunity for all the lawyers. This kind of opportunity comes in not decades, it comes in centuries. In the previous century, the new laws were enacted, and now these three set of laws are given a new look. You see, though it may seem to be, on a cursory reading, it may seem to be the same wine or old wine in the new bottle, but it is not like that. It is not like that. There are so many. It is not the rearrangement of the provisions of law. There are much more into it. And I was just reading 2-3 days back, there was one news article in the Times of India. The Delhi police is developing an app to help roll out the new criminal laws. And it was an interesting reading. What they say that in the new app, the police officers will be able to upload whatever evidence he has collected during an investigation, whether it is in digital form or scientific evidence or oral evidence or the evidence of recovery, etc. All those will be uploaded in an app, and that app will monitor the investigation. And that app will reach, it is a instant reporting of the investigation to the higher authorities in the police. So there will be a check and monitoring of the investigation by the higher authorities. So it will no longer be at the mercy of the IO only. And if some complaint is made at the investigation level to the higher police officers, he is not required to call the IO to submit an explanation. The app will be available with the higher authorities. They will look into the particular FIR, and then things will be sorted out. Come July 1, and every lawyer would be interested in moving new application by applying the new provisions in the Indian Evidence Act or the CRPC. And it would be an interesting battle at the beginning. The Judicial Academy, the National Judicial Academy, is also gearing up. The judges throughout the country are being invited for this orientation session of the new laws. Recently, in fact, 4 judicial officers from Andhra Pradesh, they have gone to National Judicial Academy for training on these 3 new laws. They met me. And different police academies, the state governments, all the state governments in their own capital, they are holding parleys, meetings, teaching sessions, academic sessions, orientation sessions. Not only that, even the paralegal volunteers are also being trained. The lawyers are also being trained by different bar councils to gear up. Because you see, if at the beginning the law is laid down incorrectly, then it will be difficult, because the wrong law would keep on applying for some years till it is corrected at the Supreme Court level or the High Court level. So the beginning of application of any new law or any new system is always very important phase in the lifeline of that particular system. So then comes the session of art of stress management in life. There was a saying when I was practicing that lawyers not purchase, they are purchased by selling the headache of the client. So the moment you accept a brief, the stress of the litigant is also transferred to you. So this topic is also a very, very apt and much needed topic to be addressed by the dignitaries who have spoken on this. Then the routine topic of will and declaration and injunction suits. Then comes the art of advocacy. This art of advocacy is a topic which is being spoken about since time immemorial. And it will be talked about, spoken about. And the more you talk, the more you think that this lawyer is not complete. He doesn't know anything. So this is one topic which every bar council should always include in the program. Then role of bar and bench in the administration of justice. This is also a very germane topic, because unless the relation between the bar and bench is congenial, healthy, the proceedings will not culminate positively and in a qualitative way. For a good judgment to be delivered by a judge, the courtroom atmosphere has to be very healthy. Anything which comes out from the pen or the mind of the judge in a stressed mind, that may not reflect the proper wordings which one is able to utter. The same judge or the same person, if he is writing something in a cool state of mind, would deliver a very qualitative judgment, but when he is stressed, he will tend to falter. He will go haywire and commit mistakes somewhere in the judgment if he is not in the cool state of mind. Then right to property, transfer of property act, specific relief. These are all the very, very popular topics. And specific relief act is now the majority of the litigation is concentrating around this specific relief act. There are less number of title suits, but more of the nature of specific relief. Then my brother Justice Chakravarti has delivered today this lecture on electronic evidence. And that is also one area in which criminal law is moving around and revolving around. Because nowadays the investigation begins when an FIR is lodged. The first step the IO does is to seize the mobile of the suspect, and he doesn't apply his mind in the beginning. His mind begins to work only when he sees something in the mobile. The contact of the prospective accused, the contact which he has made immediately before commission of crime, or other incriminating materials inside the hard disk of that mobile. So that is one important thing. Electronic evidence has gained so much of importance nowadays that one cannot do away with this part of the law. And if you have not mastered how the electronic evidence would be applicable in the given set of facts in a litigation, you are not a complete lawyer. You have to master the field of electronic evidence, particularly when you are dealing in criminal law. Not the ordinary assault case or the abuse case, but if it is a murder case, if it is a rape, if it is circulation of some obscene things or incriminating things. You see, nowadays, even in company matters, this electronic evidence are assuming significance because the exchange of communication between the functionaries of the same company or the functionaries of one company with another company, if there is a problem of winding up, amalgamation, merger, then those communications assume very significant role, and proof of those electronic messages in course of or just before the process of the difficulty of that company begins, that is also one important thing. And the whole litigation in corporate matters are taking a different shape if there is one fraudulent mail exchange between the companies or the functionaries of the companies. Then from merger, the litigation goes to fraud. And the whole dimension of the relation between the parties, warring parties, that completely changes. So that electronic evidence is very, very important these days. My journey in law and interaction with lawyers began in 2002 when I was elected as Bar Council, member of the Bar Council. And I always tell this, last time probably also I have spoken about it, that meeting lawyers who are at the end of the queue, who reside in the far away, remotest corner of the country, who don't have means to arrange for and meeting the two ends. Those are the lawyers who are really suffering, and for them, this kind of orientation program would be really, really very helpful and meaningful. Before I contested the Bar Council election, I was also thinking that all the lawyers are well off. But having seen them from the close corner and interacted them during my canvassing, I saw the reality that the grass from somewhere else looks very greener, but it is not that green when you reach to the field and the exact place. We have to do so much for the benefit of the lawyers that whatever you do appears to be incomplete or less than satisfactory. So what I am telling you and to the Bar Council is that this effort should continue. It should not stop. And hats off to the KL University, who is providing all the necessary assistance in this Solomon program and the effort of the Bar Council of AP. And I really hope that this will continue and will benefit the lawyers. And I expect and hope that I will continue to be here whenever time permits me, and I am remembered by the Bar Council. And Andhra Pradesh is so close to me that any request to come to Andhra Pradesh, I am telling you from the bottom of my heart, I can never refuse. please continue the love and affection, and I can assure you that I will reciprocate in the same way. Thank you so much.
Thank you very much, sir. The love and affection towards the people of Andhra Pradesh. Why the 5 crores of people, sir, as Chief Justice of this glorious state. This glorious state as a Chief Justice, and now the present Supreme Court Judge himself was present here and narrated his experiences not only as a lawyer but also as the chairman of the Bar Council and other things, and ultimately said, I love Andhra Pradesh. We too love you, sir. We too love you. Our advocate community always are very grateful to you, sir, when you are the Chief Justice of Andhra Pradesh. Particularly, whenever there is vacancies in the judiciary, in spite of the meager strength of the judicial officers, you try to adjust, including the martial areas and trial courts. Let's say we are very grateful to you, sir. And your open invitation, really, sir, is in our heart of hearts, saying that I'm ready to come at any time to address the advocates, and I love the advocate community. And he also told the difficulties of the advocate. That is the Honorable Justice Prashant Kumar Mishra. Give him ovation. Thank you, sir. Now, permit us, sir, for the Bar Council of Andhra Pradesh and also all the advocates, for you to felicitate you we are with the shawl and other things also.
ఆ ఎందుకంటే మంచిది ఆ 50 పడుతుంది పెట్టుకో 150 పైన 25 మీకు అర్థమైంది కదా 25
Vote of thanks by Ganta Ramarao garu.
The chief guest of the today's function, Justice Prashant Kumar Mishra ji, Justice Chakravarti garu, Chairman of the Bar Council Dwarakanath Reddy garu, Vice Chair Krishna Mohan garu, Principal Pawan garu, Bar Council members, my colleagues, and the staff of the college, staff of the KL University, advocate friends, ladies and gentlemen. This orientation program was inaugurated on 14th today. It comes to an end. We'll be failing our duty. We thank all the persons who are responsible for successful of this orientation program. We thank Sri Justice Durga Prasad garu for inaugurating and delivering a subject on the recent amendments, which is an amended version of the IPC. We also thank Sri Akula Venkatesha garu for delivering on the first subject on the education, and Sri Justice V.R. Krupasagar and Mr. Arvind Notalapati and Justice Srinivas garu and Justice C.V. Nagarjuna Reddy garu, Justice L. Nageswara garu, and Justice M. Satyanarayana Murthy garu, and Justice G. Ramakrishna Prasad garu, and Justice Subbareddy garu, and Sri Justice Venkata Jyotirmayi Pratapa garu, and Justice B.Velan Chakravarti garu, and Vikash Rajan Bhattacharya garu, who all the way traveled from Calcutta and delivered an important subject, and Sri M.E. Durga Prasad garu, advocate, for all the way coming from Hyderabad for delivering his lecture. And we will be failing to, if we don't express our thanks to the university, KL University authorities. Last occasion, during last year, this program was inaugurated by His Lordship Justice Prashant Kumar Mishra ji. Only the difference that program and this program is His Lordship inaugurated that program, and His Lordship participated in the valedictory session of this year's program. Another development is His Lordship inaugurated as the Chief Justice of Andhra Pradesh, and this year His Lordship participated as a judge of the Honorable Apex Court. After inaugurating, same day my Lordship got the good news about the elevation, which made us very happy. You may be remember, all of you, in the evening itself, we have shared that happiness by announcing from this dais. Only thing is, at that time, I was the chairman. Now I am a member. The Sri Pawan Kumar, principal of the college, Vijay Sudha garu, HOD of the law department, they have helped here not only by giving a support of the infrastructure, but also be with us all these 3 days as if they are also one of the participants. We'll be failing in our duty, unless we thank Sri Satyanarayana garu. When I first met him through Narra Srinivasa Rao, who is the standing council of this university. After having a brief discussion, after request was conceded by them, then he asked me, what is that you contribute? Then I said, sir, we are not having much comfortable financial position. We will be able to provide these food, we will bear the expenditure. Then he came forward, no, that also we will bear, the university. And he came forward, provided everything as if we are their personal guests. And we also thank the VC sir, Partha Sarathi Varma garu, and the AVS Prasad garu, Professor Pro VC sir, and Sir Dr. Venkatram garu, and Rajasekhar garu, and Dean Skilling Progress, Dr. Srinath garu. Dr. Srinath garu is instrumental for ensuring for our stay here comfortable. For every small teeny complaint, they attended and they rectified, made us stay here these 3 days very comfortably. And Assistant Dean Student Affairs, Dr. Habibullah Khan garu, and Dean Placements, ABV Prasad garu, and Dean M&H, Kishore Babu garu, and Rajesh garu, Planning and Development Dean, and Principal, already I mentioned about Pawan Kumar garu, and there are 2 yoga teachers. Sir, apart from these scheduled program which was given in the invitation, in the morning session, because there are participants are 615 in total, out of them 595 are advocates and 20 members of the law students of this university. Out of them, sir, nearly 430 people, they stayed in the campus for the 3 days and utilizing the time, morning hours, they have participated in the yoga. Some yoga tips were given to them, keeping in mind their stress and physical requirements. Very well organized yoga camp. And also that, not only that, we are given access to every facility, library and gym and all the games they made available in the morning hours, and we are allowed to freely in the campus. And I know that number of people that neredu pallu mottam kuda tinesaru. So we have a wonderful days, these 3 days, sir, and I thank.
Ramarao garu, 1 minute before closing the vote of thanks. Honorable Justice Prashant Kumar Mishra, the Honorable Supreme Court Judge, want to felicitate the young girl who danced and adored all of us. You are very fortunate the Supreme Court judge felicitating you. Keep in your mind.
I will be failing if you don't thank. We also conducted cultural programs, sir, 2 nights. And whatever these serious sessions, whatever the fatigueness, tiredness, they made us again rejuvenate them and send them their rooms. Thanks to those Satya and the team, and Ramana and the team, and Kishore and the team, who made us taken to the next level of spirit. And I know each one of the participant, they forget they are the lawyers and actually involved themselves in that entertainment created by them. We have to thank them, and we'll be failing to if you don't thank each one of the participants, because 615 people gathered here. These 3 days, every one of them behaved in a disciplined manner. So brought a reputation to our institution, because still after facing 615 advocates, university is again inviting us to this campus. It shows how disciplined you are and how restrained you are. And therefore, I thank each one of you for your discipline and participation in this program. We thank each and every person who helped us. We thank from our bottom of the heart, and you give a big ovation to the university and the staff for their aid and assistance and participation in this program. Thank you. With this, a couple of announcements. With this program is come to a stage, end stage, and all of you finished your lunch leisurely, because every day we are hunting you, come fast, come fast. Today have a leisurely, you enjoy the lunch and pack up. The buses will be there. Participation certificates, though we try to give some of them, time is not there. We don't want to keep you hungry further. Collect them. Each certificate is available. Collect them. Buses are available. Time. By 4:30, buses will be available to Vijayawada bus stand, to Vijayawada railway station, Guntur bus stand, Guntur railway station, and NRI College, Mangalagiri. Thank you. Thank you, one and all.
Thank you, one and all.
Friends, please occupy your seats. Galaxy of dignitaries and dais, members of the noble profession, advocates, very good afternoon. In fact, these 3 days of advocates residential